Okay, we're going to be dealing with CPLR 301, and we're also going to be dealing with CPLR 303. As you know, Article 3 is all about the jurisdiction. If you know, you know. All right, let me get this together. So I'm going to be looking at two very interesting, well, the second one is more interesting than the first, questions from the 2023 CPLR Quizzer. This is question 45. The traditional basis by which the courts of a state may exercise jurisdiction over a person, i.e., in personam jurisdiction, is A, presence of the person within the state. That's the answer. Here's my little handy card. Presence of the person in the state. And then this is the explanation that's given. Let me just do it in the book so you can have it nice and neat and pretty. And so it states that a court may exercise such jurisdiction over persons as might have been exercised heretofore. Generally, this refers to the exercise of jurisdiction over the person by virtue of the person's presence within the state. I might as well read the rest. 302 extends the traditional basis of jurisdiction over a person to include persons located outside the state who perform certain acts that are closely connected to New York State. So that's just giving you a little extra, but let's stick with where we're at, 301, about jurisdiction for a person within the state by the person's virtue of the person's presence within the state. Let's keep that in mind. And we see that in the actual CPLR. There it is. Section 301, jurisdiction over persons, property, or status. A court may exercise such jurisdiction over persons, property, or status as might have been exercised heretofore. Okay, keep that in mind because now we're getting to the tricky question. Question 51. A person not subject to personal jurisdiction who commences an action in New York State and on whose behalf no attorney has appeared is deemed to designate, the answer is C, clerk of the court as his agent for the service of a summons by the defendant. This is CPLR 303 this question is based on. And the answer goes into more in depth, and this is very, very interesting. CPLR 303 provides that the clerk of the court is deemed the agent of a person not subject to personal jurisdiction who commences an action in New York and on whose behalf no attorney has appeared. This provision is for the benefit of the defendant to commence a new action against the plaintiff in case the court in which he is currently being sued should not have jurisdiction over his counterclaim. If the counterclaim would be within the court's jurisdiction, defendant does not need this action since the plaintiff, by bringing suit in that court, is deemed to have submitted to the exercise of personal jurisdiction over him by that court. Okay, so this is the actual CPLR 303. Designation of attorney as agent for service. The commencement of an action in the state by a person not subject to personal jurisdiction is a designation by him of his attorney appearing in the action or of the clerk of the court if no attorney appears as agent during the pendency of the action for service of a summons pursuant to Section 308 in any separate action in which such a person is a defendant and another party to the action is a plaintiff, if such separate action would have been permitted as a counterclaim had the action been brought in the Supreme Court. Now, this is pretty interesting. I really like this question because I'm like, what? I found it to be very like, wait a minute, what the hell's going on here? But let's look at it closer. So the thing that the quizzer talks about, hold on, I gotta jump books here. This last line here is really the key. Because what it's saying is, if the counterclaim would be within the court's jurisdiction, defendant, remember, defendant is without the state, does not need this section since the plaintiff, by bringing suit in that court, is deemed to have submitted to the exercise of personal jurisdiction over him by that court. So I actually found a case. I'm going to put the link in the description. Come on. This is the case reference to exactly what this is about. It's AQ Asset Management LLC versus Levine. So what happened was that defendant who was without the state, outside of New York State, was originally in the original case. This is the defendant's counterclaim case, right? For discovery, like, well, it's not a counterclaim. It's a new action, right? Because that's what's referenced in this thing. Specifically in the quizzer explanation, it talks about the defendant who's outside of New York State, who's being sued, wanting to start a new action. See right there it is, defendant to commence a new action against the plaintiff. Okay, so there it is. So this defendant, this is the case, this is the new action, and this is an example of it. If you want to look it up, I'll also put the link in the description. But the dude who was suing this guy, this defendant, these defendants, he was from, was it Switzerland or some shit? His name is Schumacher. Hold on. Let's look this shit up. Hold on. Let's go through this. Yeah, here he is, Schumacher. So the plaintiffs are the defendants who are starting a new case, a new action, right? So the plaintiff was originally being sued by Schumacher. So let's look into this. The plaintiff, in this case, this is the new action, right? Plaintiffs AQ Asset Management LLC, Antiquorum SA, Antiquorum USA Inc., and Evan Zimmerman moved for an order authorizing the service of a subpoena upon a non-resident, there it is, non-resident, Swiss national Marcus Schumacher, through his New York attorneys. That's another key thing here, because he has his attorneys in New York. So what I was reading further down, which I'm not going to read the whole thing because it's kind of long, was that basically if Homeboy didn't have attorneys in New York, we wouldn't have been the plaintiffs wouldn't, who were defendants in his case, wouldn't have been able to serve out of the country. But Homeboy has his plaintiffs, has his attorneys located in New York City. So guess what? Homeboy's getting served. Not only that, under CPLR 303, that defendant has a right, because now he's part of that jurisdiction of that court, because he sued the defendants in the original case. He sued them. Where's my light? Why is this camera going batshit crazy? He sued them in New York, right? So that made him part of the jurisdiction of New York. So now guess what? They can file a new action against him. That's what this is about. Come on. I lost it. Hold on. So, let's see. Hold on. Let's just read some of this. So, plaintiff moves for an order authorizing the service of a subpoena upon a non-resident Swiss national, Marcus Schumacher, through his New York attorneys. Schumacher is a Swiss national residing in Geneva. On March 10, 2008, Schumacher commenced a tort action in his court against the city of New York. Paul Ware Jr., William C. Clifford, and two of the plaintiffs of this action, Antiquorum USA and Evan Zimmerman. The tort arose from an August 2007 incident that took place at the offices of Antiquorum USA, where Schumacher had served as chief operating officer for plaintiff Antiquorum at SA. The case is currently active with the next appearance scheduled for February 6, 2014 in Part 62. Plaintiffs now wish to take the deposition of Schumacher as part of the discovery in this action. Despite the fact that he is not a resident of New York, plaintiffs contend that by commencing an action against him in New York, Schumacher has submitted to this court's jurisdiction. There it is. Schumacher, not in New York, but he started that original case against these people in New York. Therefore, guess what? Now he's jurisdiction to that court where he's suing them. And request that service of a subpoena upon him be effected through his counsel in his tort case. He's basically screwed. In opposition, Schumacher maintains that this court's jurisdiction is limited to the case he started, and that if plaintiffs wish to take his testimony, they must proceed by submitting letters to Swiss authorities. No, sorry, you're wrong, because guess what? New York courts, they like these counterclaims, and it says it down here further. Service in foreign jurisdictions must be accomplished in accordance with applicable laws. Alternative methods pursuant to CPLR 3085 may only be directed if it has been shown that such service is actually impracticable. But guess what? His attorney lives in fucking New York, so it's not impracticable. It's very practicable that he's going to get served and be part of this case, okay? So in this case, however, it is conceded that Schumacher has entered New York to prosecute a tort against, inter alia, two of the plaintiffs here within. It is an ancient rule in most states, including New York, that a suitor in attendance in a court outside the territorial jurisdiction of his residence is immune from service of civil process while attending court. He's immune. Poor Schumacher. But a basic exception to this doctrine is that non-domiciliary who commences, there it is, non-domiciliary outside of the state, non-domiciliary who commences, he started a lawsuit in a state, may be, not must, may be subject to counterclaims by the defendants. Hot diggity dog. Okay, the plaintiff having submitted himself to the jurisdiction of the court. He submitted himself. Once he sued them, he submitted himself and his attorneys in New York. So bam, he got served. Shit, Schumacher is screwed. There is nothing arbitrary or unreasonable in treating him as being there for all purposes for which justice to the defendant requires his presence. That's right, because the defendant deserves to get justice and fight his counterclaim. As New York procedure has an extremely, there it is, New York procedure has an extremely permissible attitude towards counterclaims. This exception, in effect, allows any cause of action to be asserted by a defendant against a foreign plaintiff, whether it arises out of the same facts as pled in the complaint or not. Then, there it is. Indeed, CPLR 303, we're seeing the law in action. Let's go. We're not even attorneys. The commencement of an action in a state, we already read all that shit. Thus, a non-domiciliary who commences an action in New York State becomes amendable to the service of a summons for a new action. There it is. By a defendant in the first action. And that's what this case is. It's the new action. So if you want to look it up, I'm going to put a link in there. But I found this, when I first read the card, card because I'm studying, right? When I first read the quizzer question, I was like, huh? I did like 30 huhs. But here it is in black and white in case law. 303 not only confers jurisdiction over the person of a non-domiciliary plaintiff, but it also explicitly designates New York agents to accept service of a summons on behalf of that non-domiciliary, his attorney, if he has one, or there it is, the answer, the clerk of the court, if he does not have an attorney. So there we have it. So in conclusion, I just want to reread the answer that was in the quizzer. This provision is for the benefit of the defendant to commence a new action against the plaintiff in case the court in which he is currently bringing suit would not have jurisdiction over his counterclaim. So then it goes on to say if the counterclaim would be within the court's jurisdiction, defendant does not need this section. But since the plaintiff, by bringing suit in that court, is deemed to have submitted to the exercise of personal jurisdiction over him by that court. And so I had to read that several times for it to really like kick into my head, because it's saying for the benefit of the defendant. So that guy from Switzerland, he was not within the jurisdiction. So in order for the defendant to pull that counterclaim, he had to pull 303. So let me give you a quick example. So if the person that was suing the defendant who started the new action was in New York State and of the jurisdiction, he wouldn't need to use 303. But because he is doing that counterclaim and starting a new action against the guy that's suing him in Switzerland, and that person from Switzerland is not in New York State jurisdiction, then he's able to implement CPLR 303. I hope that makes sense because I had to read it 14 times.